just to that. Okay. All right, you're Ralph Morrison there at the jail?
Good morning, sir.
Morning. Case number 21 CR 186, State of Iowa versus Ralph S. Morrison. This hearing is a bail review getting conducted from the jail. Mr. Morrison's attorney is Mr. Wagner, but I understand he's in Wilmington or somewhere today. You're going to cover for him, Mr. Armstrong. Okay. All right. Mr. Morrison was in, also Mr. King on behalf of the state. Mr. Morrison was indicted by the grand jury for failure to comply, a third-degree felony, received stolen property, a fourth-degree felony. The court arraigned him and set the bond in the absence of counsel Wednesday, and so under Rule 46 is required to conduct a review hearing within 2 business days. Mr. Morrison, am I correct? Did you tell me that the arraignment that you had you're serving a sentence out of municipal court? Okay, all right. So with that said, Mr. Armstrong, anything you'd like to ask or say? The bond was $10,000 plus OR. So, all right. Well, what we'll do is we'll leave it the same, and then if he does get released early from the bond before this case is completed, obviously it can be revisited at that time. All right. Thank you, Mr. Morrison. Thank you. I don't think I've ever been given that greeting before. Sure. Okay, this is case number 21 CR 190. Oh, where's that one? Okay, case number 21 CR 190, State of Iowa, which is Robert Hurley. Robert E. Hurley. Is your Robert E. Hurley appearing from the jail? All right, Mr. Armstrong is his attorney. This hearing is being conducted by Zoom. And Mr. King is on here on behalf of the state. And Mr. Armstrong indicated he'd like to speak to your client for a minute. Well, I'm going to create what's called a breakout room here, Mr. Hurley, in which I'm going to put you and your attorney into a room by yourselves so that no one else will be able to see you or hear you. Deputy can leave the room there. You'll have to, you may have to click on a button that says join, and you can see breakout room. And then when you're done, and there'll be a button I think you click that says leave breakout room. place back on the record then.
Okay.
Okay, this is case number 21 CR 190. They will have versus Robert E. Hurley. We're back on record, Mr. Hurley, Mr. Armin Trout. This is a bail review hearing. The defendant was arraigned, I believe, Wednesday on 2 counts of assault on a peace officer for 3 felonies, and the court appointed Mr. Armin Trout as counsel. In the absence of counsel, the court set bond in the amount of $17,500 plus OR, and pursuant to Rule 46, since that was done in the absence of counsel, it's necessary to conduct a review hearing within 2 business days. That is the point of this proceeding. So, with that said, Mr. Armin Trout, anything you would like to say?
He has a prior felony convictions. Being serious of the allegations, I don't believe the officer was protected from last time I've ever seen that. He does own property. They bring him under arms. He has ties. Consider that. They would hear all. Yes, it would be great. Yes, consider that.
Okay.
Thank you, Your Honor. This is state's position, always appropriate at this time. I do point out that this defendant currently has a felony repossession in Green County. Actually has a warrant for that case. That case had to be issued in June due to a bond violation, and that case is still out. So based on all that, it's the state position that bond is appropriate at this time.
All right. You say he owns property in Greenfield? He lives in Zeeman. You have property there? You own it? It's in your name? And is there anyone else living there now? All right. And is that property free and clear?
Yes, sir.
All right. Well, one thing we'll find in is that you're going to be required to reimburse the county for your attorney fees since you own property, and the court will order that clerk to note that in the record. Well, given the fact that there's another case pending and they failed to appear there on a bond violation warrant, I'm going to leave I'm not going to grant no R bond, particularly the nature of the allegations. That the court will order that bail be reduced to $10,000 plus OR, and on the condition that if you do make bond, you're going to reside in what is that, 118 Spring Street?
Smith Street.
What?
118 Smith Street.
118 Smith Street in Greenville during pendency of this action. And all the other conditions remain the same. All right, thank you.
Who would you like to see next?
Daniel Wallace.
Wallace.
All right, you are Daniel Lee Wallace.
Yes, sir.
All right, this is case number 21 CR 118, State of Ohio versus Daniel Lee Wallace. Wallace is appearing by video from the Justice Center. His attorney is Dennis Kirk. He's appearing from his office. This hearing being conducted by Zoom due to COVID-19. Assistant Prosecutor King is appearing from his office, and also we have Probation Officer Fulton on the screen as well. Now, Mr. Kirk, you and your client both stipulating this hearing being conducted by Zoom virtually rather than in person. You're muted there, Mr. Kirk.
Yes, Your Honor.
And you're in agreement with that as well, Mr. Wallace?
Yes, sir.
All right, thank you. All right, now, Mr. Wallace, since you're not in court with your attorney, if any time during this hearing you need to talk with him or ask him a question, you just tell me, and then I can put you and him in what's called a breakout room, and then it'll be just the two of you on the screen talking to each other. No one else will be able to see you or hear you, and it won't be recorded. And then once you're done, then we'll come back. Okay. All right. The defendant is charged in a 6-count indictment with 3 counts of trafficking, heroin, and 3 counts of aggravated possession of fentanyl-related content. I believe we have a trial date set up November the 15th. The court was informed that the parties have reached an agreement, set this matter today for a plea hearing. Now, Mr. Wallace, I've been presented with a plea of guilty form, which is a 3-page document that's been prepared by the prosecutor's office from a form they have in their computer. And I'll hold this up to the screen to make sure you recognize that. That has your case number and everything on it. You recognize that form?
Yes, sir.
Okay, on page 3, there are signature lines, and about halfway down the page, there's a sentence that says, I enter this plea voluntarily, and immediately below that, there's a signature, which is very good, by the way. I don't get as many people sign their names allegedly. Daniel Wallace, and is that your signature there?
Yes, sir.
All right, well, congratulations on your penmanship. It's a lot better than mine, and all attorneys that I know. Okay. Now, did you sign this agreement yesterday?
I think Friday,
Monday, okay. And was Mr. Kirk? Go ahead.
November the 1st,
All right, that would have been Monday, he's right, okay. All right, and so Mr. Kirk went over that with you and explained it to you before you signed it? When you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing? And did you have enough time to fully consider this matter before making this decision? Do you feel that you were rushed or pressured in any way into doing this? And you're entering into the agreement to plead guilty voluntarily? All right, now the first page of the agreement states that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 3. Both of those are trafficking and heroin. Under section 2925.03A1 of the Ohio Revised Code, both are 4th-degree felonies. And it further states that you understand that the maximum prison term for each of those, if prison is imposed, it could be 18 months. Minimum is 6 months if prison term is imposed, but anything in between those two. There could be a fine of up to $5,000. There could also be a license suspension of between 6 months and 5 years. Now, you understand all of that? Now, if you are convicted on both of these offenses and sentenced to prison on both of these offenses, those sentences could be ordered to be served consecutively, meaning one after another. So that means that the possible maximum sentence for these 2 offenses could be 36 months in prison and a fine of $10,000. Do you understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you on community control, probation, post-release control, parole from any jurisdiction at this time?
No, sir. Never been on it.
Okay. Now, under the law, if you are sentenced to prison for these offenses, once you complete the prison term that's imposed by the court, the adult parole authority may, at their option, decide that you should be put under what's called post-release control for a period up to 2 years. And so that means that you would be supervised on the term set by the adult parole authority, because in court the judge has nothing to do with that. If they decide to do that, that means that you'll be under their supervision, and if you don't comply with those, if they find you fail to comply, they could return you to prison to serve an additional period of up to 9 months for any one violation, but there is a cap or limit of half of whatever prison term is imposed for all violations. But if you committed a felony while under post-release control, then in addition to whatever sentence the judge in the new felony case would impose, that judge would also sentence you, in this case, for an additional period of 1 year, or whatever time was left on the 2 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, under the law, these are not mandatory prison offenses, Mr. Wallace, so I could impose what's called community control or probation, meaning that instead of being sent to prison, you can be put under supervision of a probation officer under the term set by the court for a period of up to 5 years. And if during that period of time the probation department felt that you were not compliant, they would have to file a written notice of that with the court, serve a copy upon you, and then you would be entitled to have a hearing and be represented by counsel. If the outcome of that hearing was that you had failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for 36 months, fine you $10,000. Do you understand that?
Yes, sir.
All right, now the indictment alleges in count 1 that on or about December 16, 2020, in Highland County, Ohio, you did knowingly sell or offer to sell heroin, Schedule 1 controlled substance amount equal to or exceeding 1 gram plus than 5 grams, in violation of Section 2925.03A1 of the Ohio Revised Code. And count 3 alleges that the same offense occurred on December 17, 2020, in the same amount in Highland County, and the same statutory violation. So each of those, as I said, are trafficking in heroin, 4-3 felonies, carrying a possible prison term between 6 and 18 months and a fine of $5,000 plus the license suspension 6 months to 5 years. Now, Mr. Wallace, do you understand what it is you've been charged with by the state, what they say you did, when, where, and how they allege that you did it?
Yes, sir.
And you discussed the nature of the charge, the evidence of the case, the possible legal issues of the case, the possible defenses might try to raise a trial, and the possible outcomes of a trial with your attorney.
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made against you to plead guilty here today? Now, on page 2, down at the bottom, there is about a little over 4 lines, credits and bold and underline. Just hold those up and show you what I'm talking about right there. I'm going to read those. Defendant shall enter a plea of guilty to count 1 and count 3. State will dismiss the remaining counts. State defense jointly recommend 9 months incarceration on count 1, consecutive to 9 months incarceration on count 3. Defendant agrees to repay by money to the Highland County Drug Task Force in the amount of $480 as part of plea consideration. Now, is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, I don't know if I'm asking this or not. Have any threats been made to make you plead guilty?
No, sir.
And are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
Blood pressure, me.
Okay, does that interfere with your ability to understand what's going on?
No.
Okay, all right. Now, under the law, Mr. Wallace, the matter of sentencing is up to the judge, not to the parties. And so, even though both parties are in agreement with what sentence ought to be imposed in these cases, if you plead guilty, the judge is not bound to follow those. So if you plead guilty, I could decide that 9 months isn't the correct sentence and sentence you to an amount lesser or greater up to 18 months in each charge. Do you understand that?
Yes, sir.
Now, Mr. Wallace, do you hold any kind of a license or certificate from any state agency, any kind of a occupation or a profession?
No, sir.
Right, and you have certain constitutional rights you must understand before I can accept the plea of guilty from you. First of all, you have counsel, right to counsel. Mr. Kirk was appointed for that purpose since you didn't have the funds to hire an attorney. He's not appointed simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide you do not want to plead guilty, you're still going to be represented by Mr. Kirk. He'll defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Right now in the Constitution, Mr. Wallace, you have a right to a jury trial on these charges, which means that 12 people will be selected from a group of citizens that were summoned for jury duty from this county. They all live in this county. And after 12 of them were selected, the evidence would be presented, and then the jury would be instructed about the law on the cases, and then that jury would decide by unanimous verdict, being all 12 of them would have to agree, as to whether or not the state proved guilt or proved guilty. That. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means give up your right to have a jury trial. In that case, you'd have a court trial, meaning the judge would be the one who would hear the evidence instead of the jury. The judge would apply the law, the judge would decide whether or not the state proved guilt by proof beyond a reasonable doubt. You understand that? Now, under the Constitution, Mr. Wallace, you have the right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. You understand that? Under the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily at your request, the court issues a court order, that's a subpoena, that requires that those people come to court to testify for you, if you want them to, even though they don't want to be here, which is the same way that the state's witnesses are forced to come into court to testify against you. Do you understand that? Now, in the Constitution, Mr. Wallace, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't. It's totally your decision. If you decide you're not testifying, the fact that you did not testify in the case cannot be used against you in any way by anyone at any time in the proceedings. And in fact, no one's allowed to even talk about that except in one situation, which is if there's a jury trial and you don't testify, then the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that? Right, now, under the Constitution, Mr. Wallace, you're presumed innocent of these charges until proven guilty by the state of Ohio, and every essential element of each charge is proved beyond a reasonable doubt. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of these charges. In fact, under the law, you don't have to know any evidence in your defense at all at trial. Now, you may, but you're not required to. But whether you present any evidence in your own defense or not, the burden of proof remains upon the state of Ohio to prove your guilt on every essential element of each defense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that? Now, Mr. Wallace originally entered pleas of not guilty to these charges. Those pleas denied the allegation in the indictment, denied he committed any crime, and it exercised on both all the rights that I've just described. If you change your plea from not guilty to guilty today, that is the opposite of not guilty plea. Guilty plea admits the allegations in the indictment, admits that they're a crime, but you committed that crime. And that, in each count, and the ones you're pleading guilty to. And that plea would waive or give up all the rights I just described, except one, the right to have an attorney. Because you always have a right to have an attorney no matter what your plea is, with that exception. Your plea of guilty would waive or give up the right to have a jury or court trial, waive or give up the right to confront witnesses an issue to cross-examine through your attorney, waive or give up the right to use the power of the court to compel or force witnesses to come into court and testify for you, the same as the state. Waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. But the way to give up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove that you're guilty. It also waives gives up the right to file an appeal, which you think you could have had up to this point in the case, unless I sentence you to maximum sentence or under other limited circumstances in which you could file an appeal. That appeal would have to be filed for 30 days for sentencing intervening filed. And finally, your plea of guilty subjects you to being sentenced immediately by the court, which I believe is what's suggested here in this agreement. So, do you understand all that, Mr. Wallace?
Yes, sir.
And are you a U.S. citizen, Mr. Wallace?
Yes, sir.
Now, do you have any questions about either of the charges or possible penalties, sir? Do you understand? Do you have any questions about the plea agreement? Do you understand it? Any questions about your constitutional rights that I just went over? You understand that? You have any questions about the plea of guilty? What the consequence of that would be if you use that here? You understand? Is there anything you need to speak with Mr. Kirk about before we go any further? You have any questions about anything I've explained here this morning? All right. Then, Mr. Wallace, this is your decision to withdraw your not guilty plea, plead guilty to counts 1 and 3 of the indictment pursuant to the terms of the agreement that we've just gone through. All right. Then, as to count 1, that alleges in on or about December 16, 2020 in Highland County, Ohio, you did knowingly sell or offer to sell heroin, a Schedule 1 controlled substance amount equal to or exceeding 1 gram, less than 5 grams in violation of Section 2925.03A1 of the Ohio Revised Code. A fourth-degree felony carrying possible prison term between 6 and 18 months, a fine of up to $5,000, and a possible license suspension of 6 months to 5 years. How do you plead? All right, count 3, which alleges the same offense, except that it states that it occurred on or about December 17, 2020 in this county, but other than that, all the elements are the same penalty, same section number of the revised code. How do you plead? All right, thank you. All right, the court finds that on this day, in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver say. The court accepts the pleas, finding the defendant guilty of counts 1 and 3, trafficking in heroin, fourth-degree felony as charged therein. The court dismisses the remaining counts of the indictment. All right, I took a quick glance at the discovery that here the defendant has been previously convicted and served sentences for felonies. Is that correct? All right. Well, as much as there's a stipulated recommendation and there's been previous criminal violations, the court is going to go ahead and proceed with sentencing forthwith. Mr. King, anything from the state?
Only one is contained in the Your Honor.
Guilty.
The restitution in this case is $480. Thank you.
Mr. King? I'm sorry, Mr. Kirk?
If Your Honor, that's first of all, the agreement. I find this, according to the discovery of 2 prior felony cases, last week in 2008. So, in this particular case, it appears to be often be a fair offer of the facts and circumstances at this time. He has owned up to the allegations of likelihood to say, so that's the court's fault. Thank you.
All right, Mr. Wallace, is there anything you'd like to say? Not required to say anything, but I'll hear whatever you would like to tell me. All right, well, I do note that you had previous conviction in 2002 out of Bellbrook for a third-degree felony possession of cocaine, and then it looks like in 2008 you had conviction in this court, received a 4-year, 11-month sentence. So, based upon the prior history and the nature of these offenses, the court will order that the defendant be sentenced to the Correction Reception Center at or in Ohio for a period of 9 months on each count, and that those are ordered to be served consecutively to one another. The court imposed those consecutively. That was a stipulated agreement by the parties, plus the court finds that the defendant's prior criminal history warrants a consecutive term for protect the public. Also, they were committed as part of one or more courses of conduct, and the harm is such that one sentence will not adequately reflect the seriousness of the offense, and the sentences that are being imposed are not disproportionate to the seriousness of the crime. The defendant is granted 36 days of jail time credit. According to this, you're arrested on, oh wait, that's not correct. You're arrested on September the 1st, is that correct, Mr. Wallace?
Yes, sir. I was arrested on August the 18th, but I had a fight case with Marion County, so it's really August 26th.
Okay, well, August 26th is when you were released to come back here?
Yes, sir.
Okay. All right, and according to this, then that'll be 5 days in August, 30 days in September, 31 in October, and today is the 5th, so that'll be 71 days. Okay, so you're granted 71 days of jail time credit. Now, upon completion of this sentence, it is possible that the adult parole authority may, at their option, they don't have to, but they can't do it if they want to, put you on post-release control supervision for a period of up to 2 years under the terms they set. And if they determine while you're being supervised, pursuant to those terms, that you have failed to comply with those conditions, they can return you to prison, even though you serve the entire term set by the court for an additional period of up to, in this case, 9 months for one violation, which would also be the cap, since it's half of the term for all violations. But if you commit a new felony while under post-release control supervision, and in addition, whatever sentence the judge in that new case imposed on you, the judge is also authorized to sentence you in this case, or for committing those offenses while under supervision in this case, to an additional period of 1 year, whatever time might be left on that period of post-release control, whichever is greater or more. And if that happens, then that has to be served separately the sentence in the new case. There'll be no fine imposed, there'll be no suspension of driving privileges imposed. It is ordered that the defendant pay $480 in restitution as a subsequent order to the Howard County Task Force, and that be paid to the Howard County Victim Witness restitution escrow account, and the defendant will pay any service fees provided that they charge for that service. All right, is there anything further from counsel? All right, you're remanded back to custody, Mr. Wallace. Thank you. All right.
Mr. Clifford?
Mr. Clifford?
Is that who's coming in? Whoever's sitting down will take it. Is that Mr. Clifford?
Yes, sir.
All right. All right, Sir Bobby Lee Clifford, appearing from the jail. All right, this is two cases involving the same defendant. Case number 21-CR127, case number 21-CR154. Both styles State of Ohio versus Bobby Lee Clifford. This hearing being conducted by Zoom because of the COVID-19 concerns. Mr. Clifford is appearing by Zoom from the jail. His attorney is Dennis Kirk, appearing from his office, and representing the state, appearing from his office, is Assistant Prosecutor King. Now, Mr. Kirk, you and your client are both stipulating to this hearing being conducted by Zoom remotely and waiving his personal appearance in front of the court at the courthouse.
Yes, sir.
And you're in agreement with that, Mr. Clifford? Okay. Keep your voice up if you would. I can hear you, but I'm not sure we're going to be getting this, how strong you're reporting. All right, in case number 21-CR127, the defendant's charged with 1 count of aggravated possession of methamphetamine. In case number 21-CR154, he is charged along with the co-defendant with breaking and entering in effect, as well as a forfeiture specification that seeks to forfeit, looks like a 2003 Volkswagen Beetle vehicle. Now, I've been presented, Mr. Clifford, with plea of guilty forms in these two cases. And these forms are prepared by the prosecutor's office from their computer, and they put in the information about your case that's relevant. And then they print those out. And I'll hold these up to you. And first one is case number 21-CR154. It says you're going to plead guilty. You see that form there?
Yes, sir.
Do you recognize it?
Yes, sir.
And on page 3, there are some signature lines, and there's a sentence about a little over a third of the way down the page. It says, I entered this plea voluntarily. And right below that, there appears to be a signature of Bobby Clifford. Is that your signature next to my finger? Okay. And then in case number 127, says you're going to plead guilty. Actually, the one I just showed you was 154. 127 says you're going to plead guilty to aggravated possession of methamphetamine, and 154 says you're going to plead guilty to breaking, entering, and enforcing specification. And so I'll hold up 127 now, and that looks like also the signature of Bobby Clifford. Is that your signature I just held up?
Yes, sir.
All right. Now, Mr. Clifford, when did you sign these two plea agreements? Couple days ago?
It was your address on November the 1st.
Monday? All right. I was there at the jail. And did Mr. Kurt go over these with you and explain them to you before you signed them?
Yes, sir, it did.
And you understood that when you signed those, that was agreement in each of those documents to plead guilty, meaning there wouldn't be a trial in either case, and the next step would be a sentencing hearing.
Yes, sir.
And did you have enough time to fully consider that matter before signing each agreement?
Yes, sir.
Right. And are you entering into the agreement to plead guilty in these two cases voluntarily?
Yes, I think it
Okay, well, we'll get to that, but I was going to ask if this is a voluntary act. One thing I didn't mention at the beginning of the hearing, Mr. Clifford, is that since you're not in the courtroom sitting next to your attorney, and to be able to ask him questions, if there's anything that comes up during this hearing where you would like to ask him questions about that, or to talk to him about something relating to this proceeding, you just tell me, and then I can put you and him into a breakout room, which would be the two of you on the screen alone. No one else will be able to see you or hear you. It wouldn't be recorded, okay? All right. Now, you're entering into each of these agreements voluntarily. Is that correct?
Yes, sir.
All right. Now, on case number 127, says you're going to withdraw your non-guilty plea and plead guilty to the aggravated possession of methamphetamine charge under section 2925.11 of the Revised Code, 5th degree felony. And in case number 21 CR 154. Says you're going to withdraw your non-guilty plea to count 1 breaking and entering under 2911.13a of the Revised Code, as well as to the portion specification in count 3 of 2941.14.17. Now, each of these forms indicates that the maximum penalty for count 1 is 12 months because these are 5th degree felonies. The minimum is a 6-month sentence. There's also a fine available of $2,500 in each case. And as to the aggravated possession of meth charge in the 127 case, there's also the possibility, since it's a drug offense, of a 6-month to 5-year license suspension. Do you understand all of that?
Yes, sir.
Right now, in the event that you plead guilty or convicted of both of these offenses, the court could impose a prison sentence in each case and order them to be served consecutively, meaning one after the other. So that means that they would be added together. So that makes the maximum possible sentence 12 months on each, 24 months if it were to be served consecutively. Do you understand that? Now, are you facing any felony charges anywhere else? And are you on probation, community control, parole, or post-release control for a felony in any jurisdiction? Now, under the law,
That's not correct.
I'm sorry, go ahead.
State law is supposed to police control.
Oh, okay. When was that filed with the court?
The 21 CR 154 case, it was filed on September 3rd.
Yeah, there is. All right, yeah, it does appear that you are on post-release control for a failure to comply out of Montgomery County. And on September 21st, the date of that document, it indicated you had 298 days left. So under the law, if you are convicted of these offenses today, then in addition to the sentence to be imposed of 9 months on each charge, the court could also then sentence you to a period of 1 year for committing these offenses while under post-release control from the Montgomery County case. The law says it's 1 year, whatever time is left on that post-release control, whichever is more. Since you had less than a year left on your post-release control as of today, that means that 1 year would be the sentence that is more than what's left. That would be served consecutively to whatever sentence is imposed by the court. So if there's 24 months maximum for those 2 charges, 2 years, then I could also add another year for the violation being committed under post-release control. You understand that?
Yes, but I could have been served.
Well, the time is on your, you had 3 years. And if you were in custody, yeah, but I mean, going to programs and so forth doesn't count. I mean, it counts as a day, but it doesn't count on the 1 year because if you have less than a year left. Right now, you've got about, that was 298 days on September 21st, so that would be, been another 45 days since then, so that puts your time down to about 243 days. But under the law, you, because that's less than a year is 365 days, you could be sentenced for the new felonies and an additional 1 year. Yeah, they did give you credit because it was during your 3 years. You know, if you're on post-release control and you go back, you go into a program or if you go back to prison, you know, that's on the 9 months that they can sanction you for one. You can get one sentence of 9 months or half of the prison term. You can go back to prison for. That's a year and a half. But if you get a new conviction, you can get a year or whatever time's left on the period of post-release control, regardless of those previous sanctions. Those aren't related to this. So here's the bottom line. If you plead guilty here today and are sentenced to prison, in addition to whatever sentence you can get on these 2 charges, you can also be sentenced to an additional 1 year because you're still on post-release control and being convicted here today. And that sentence has to be served consecutively to the sentence in the other 2 cases. You understand that? All right, now if that changes your mind and you want to talk to Mr. Kirk, just let me know and I'll put you in a breakout room with him, or we can just recess this hearing and come back another day. It's whatever you want to do. All right? No problem. I'll put you in a breakout room here, and there may be a button there on your screen you'll have to push to join it. Okay, we're back on record. Mr. Clifford and Mr. Kirk are both rejoined in the Zoom session. All right, are we ready to go ahead and proceed, Mr. Kirk?
I believe so. I did answer the questions that he had, and I believe we're ready to go forward.
Okay. So you understand then what the situation is then with the PRC time, Mr. Clifford? All right. Now, under the law in this case, if you are sentenced to prison and serve the prison term imposed, post-release control is optional, and there's been some changes in it. It's now, for these offenses, up to 2 years. Meaning you could be on post-release control, or you may not be. It's up to the adult parole authority. Your other case is mandatory. But on this one, it's optional. And so, if they do decide to do it, the maximum term is 2 years. And if during that period of time they allege, if you are on post-release control and APA feels that you are not compliant, then, as we just talked about, they can return you to prison to make you serve an additional period of up to 9 months for one violation, up to a maximum of half of the prison term for all violations. But if you commit a new felony while under post-release control supervision, then in addition, whatever sentence would be imposed for the new charge, the court in that case would also then sentence you to an additional period of 1 year, whatever time would be left on the period of post-release control imposed by the parole authority, whichever is more, greater. And if that occurs, that would be served consecutively to the sentence in the new case. Do you understand that? Speak up, please.
Yes.
Okay, thank you. Now, under the law, I don't have to sentence you to a prison term for these offenses. I can impose community control or probation, which is a period of supervision of up to 5 years on a term set by the court, rather than being sent to prison. That would be supervision by the county probation department as opposed to the parole officer. If during that period of time the probation department felt that you were not compliant, they would file a written notice of that with the court. You'd be served a copy, there would be a hearing, and if the outcome of the hearing was that you failed to comply, then at that time the court would revoke your community control in each case, essentially in each case, to a term of 12 months and fine you $2,500 consecutively. So that'd be a total of 24 months and $5,000 fine. You understand that? Right now, 21-0127, the indictment alleges that on or about March 23, 2021 in this county, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine in violation of Section 2925.11. That's a 5th degree felony with possible sentence between 6 and 12 months in prison, fine of $2,500, and possible license suspension of 6 months to 5 years. Count 1 in 21-0154 alleges that on or about June 14, 2021 in this county, you and Joshua L. Moore did knowingly by force, stealth, or deception trespass in an unoccupied structure, to wit, a barn, lean-to, with purpose to commit therein a theft offense as defined in ORC Section 2913.02A1 or a felony, in violation of 2911.13A of the Ohio Revised Code. That's the charge to be either breaking and entering with various possible prison from 6 to 12 months to fine of 20 months. Count 3 then is the forfeiture effect that alleges that on or about June 14, 2021 in Hyde County, Ohio, you had in your possession a 2003 Volkswagen Beetle VIN number listed in the indictment. I won't read it. Subject to forfeiture due to its instrumentality in the commission or facilitation of the offense, as defined under 2941.14.17. And the penalty for that is the loss of that vehicle and ownership of it to the state agencies investigating and prosecuting this case. Now, Mr. Clifford, do you understand the charges and the possible penalties in each case? And you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible offenses you're trying to raise in the cases, and the possible outcomes in each case with your attorney.
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Now, are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Are you taking any prescription drugs?
Well, I take several take a couple other meds, psych meds,
All right, they don't interfere with your ability to understand what we're talking about here today, or for you to be able to communicate your understanding or concerns to the court. You're okay on that? Okay. Now, I'm going to read the page 2. Each of these documents have a couple of sentences that are printed in bold and underlined that are and actually the 154 is actually about a little over 4 lines. So I'll read 127 first. This is bold printing underlined on page 2. Defendant shall enter plea of guilty to the indictment. State defense jointly recommend 9 months incarceration consecutive sentence imposed in case number 21-CR154. Now, on page 2 of 21-CR154, those lines read as follows. Defendant shall enter plea of guilty to count 1 and count 3. State will dismiss count 2. State defense jointly recommend 9 months incarceration consecutive sentence imposed in case number 21-CR127. Defendant shall cooperate fully in the prosecution of the defendant. Defendant agrees to forfeiture count 3. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than you should plead guilty here today? Under the law, the recommendation on sentencing is not up to the parties, but it's up to the judge. So even though the recommendation is what the sentence ought to be, that will be up to the court. And so if you plead guilty, I don't have to follow that recommendation. I could make it 12 months in each case consecutive, plus I can impose the PRC time as well, which I'm likely to do, because I always do. So, you understand that?
Yes.
And what is the amount of restitution that needs to be made, Mr. King?
There is no restitution, Your Honor.
Okay. I'll just make a notation of that then there. All right. Now, do you hold any license or certificate, any state regulatory board for any kind of a profession or occupation? Now, you have certain rights. You must understand, Mr. Clifford, before I can accept your guilty plea in these 2 cases. First, you have the right to counsel. Mr. Kirk's been appointed to represent you, since you could not afford to hire your own attorney. His appointment wasn't simply to work the case out, but to provide any defense to be available to you under the law that you would like to provide. So, if you decide you don't want to plead guilty, that you want to defend against either or both of these charges or cases, then he'll continue to do that, including defending you at trial if that's what you want in each case. Do you understand that?
Yes, sir.
Now, under the Constitution, in each of these cases, you have a right to have a jury trial. And that means that 12 people will be selected in each case from a group of citizens that live in this county that are summoned for jury duty on your trial day. After they were selected, the evidence will be presented, and then they'd be instructed in the law in each case. And in each of these 2 cases, then a jury would have to find by unanimous vote, meaning all 12 have to agree, as to whether or not the state proved your guilt in either or both cases of any charges. Now, if you decided you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial in that particular case, and then, in that case, or both, if that's what your decision was, then you would have what's called a court trial. And that means that the judge is the one that hears the evidence instead of the jury, judge applies the law, and the judge decides whether or not the state proved your guilt in either or both cases. Do you understand that?
Yes, sir.
Now, under the Constitution, in each of these cases, you have a right to confront the witnesses against you in open court and to have your attorney cross-examine. So what that means is that in each trial, witnesses against you would have to come in the courtroom, testify in front of you and your attorney and anyone else is present. After the prosecutor was then asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case in each of those cases. Do you understand that?
Yes.
Right, now, Mr. Clifford, in each of these cases, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses in either of these cases that you are not certain are going to come in voluntarily, at your request, the court will issue a court order. That's called a subpoena. And that forces those people, in that case that you think, come to court to testify if you want them to, because they don't want to be here. And that's the way the state's witnesses would be required to come to testify against you in each of the cases. Do you understand that?
Yes.
Under the Constitution, in each of these cases, you have the privilege against self-incrimination, which means you cannot be forced to give evidence or to testify against yourself in the case. So no one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify in either or both cases, the fact that you did not testify cannot be used against you in any way by anyone at any time. And in fact, no one's even allowed to comment about it in either or both cases if you don't testify. With one exception. If there's a jury trial in either or both cases, and you do not testify, then the judge will instruct the jury in that case that they cannot consider that for any purpose because that is your right. Do you understand that? Under the Constitution, Mr. Clifford, you're presumed innocent of each of these offenses until proven guilty by the state of Ohio by proof beyond reasonable doubt. What that means is that the burden of proof isn't upon you to prove that you're not guilty of either or any of these charges. Instead, the burden of proof is upon the state. Because you're not even required to present any evidence at trial to defend yourself. You can, but you're not required to. But whether you do or not, in each case, the burden will still remain on the state of Ohio in each case to prove your guilt, prove beyond a reasonable doubt all the essential elements of each of the offenses charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now, originally you entered a plea not guilty in each case. That plea denied the allegations, denied you committed a crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty in either or both of these cases, that plea is a complete opposite of the not guilty plea. The guilty plea admits the allegations in each count of the indictment to which you plead guilty. It admits that there are crimes, that you committed those crimes, and those pleas and those counts would waive and give up all of the rights that I've just described, except your right to have an attorney. Because you always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty would waive and give up your right to a jury or court trial in each case. You would waive and give up in each case your right to confront witnesses against you and cross-examine through your attorney. You would waive and give up in each case your right to use the power of the court to compel or force witnesses to come to the court to testify on your behalf, same with the state. You would waive and give up in each case your privilege against self-incrimination because you're saying you're guilty and that's what you define as guilty. In each case, you would waive and give up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. You would also waive and give up in each case your right to file an appeal on any alleged violations of your rights you think could have happened up until this point. Now, I should sentence you to the maximum in either charge in either case, or under other limited circumstances, there may be a right to file an appeal, but any appeal that you file would have to be filed within 30 days of your sentence and entry being filed. You understand that? Now, it also subjects you to being sentenced immediately by the court, which is what's being proposed here today. You understand that? You're subject to being sentenced immediately by the court, which is what's likely to happen here today. You understand that? Okay. And you are a U.S. citizen, Mr. Clifford? All right. Now, do you have any questions about any of the charges in either of the two cases? You understand that? And the evidence. Have any questions about the plea agreement in either case? You understand them? Any questions about the constitutional rights I'm explaining to you here this morning? You understand those? Do you have any questions about the constitutional rights that I'm explaining? Do you understand those? Have any questions about the plea of guilty, what it means, or what will happen if you enter those pleas here today in these two cases? You understand? Is there anything else you need to speak to Mr. Kirk about before we go any further? Do you have any questions at all about anything I'm explaining to you here this morning? Then is your decision, Mr. Clifford, to withdraw your not guilty plea in these two cases, plead guilty in accordance with the terms of the agreement in each case we've just gone over here this morning? Okay, then as to count 1 in 21 CR 127 that alleges that on or about March 23, 2021 in Highland County, Ohio, You did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, in violation of Section 2925.11 Ohio Revised Code, charge of aggravated possession of methamphetamine, a 5th-degree felony, carrying possible prison term between 6 to 12 months, a fine of $2,500 for possible license suspension of 6 months, 5 years. How do you plead? All right, then as to count 1 and 21 CR 154, which reads in on or about June 14, 2021, in Highland County, Ohio, that you and Joshua Moore did knowingly by forced stealth deception, trespass in an unoccupied structure to wit or lead to or purpose to commit therein a theft offense, as defined in ORC Section 2913.02A1 or penalty, violation of Section 2911.13A the Ohio Revised Code, charge of breaking and entering, a 5th-degree felony, carrying possible prison term between 6 to 12 months, a fine of $2,500. How do you plead? All right, then count 3 in that same case, which alleges that on or about June 14, 2021, in Highland County, Ohio, you had in possession of 2003 Volkswagen Beetle with VIN number listed in that indictment, subject to forfeiture due to its instrumentality in the commission, facilitation of the offense, as defined in Section 2941.14, 0.17 Ohio Revised Code, which will result in a loss of the ownership of that vehicle to the state. How do you plead? All right, what is the question? Yes. You can answer about it, but yes. All right. Thank you. All right, the court finds on this day, in open court, defendants violate all constitutional rights. They know intelligent voluntary waiver the same, pursuant to Rule 11. Please accept it, order filed. Defendant is found guilty in count 1 of the charge as set forth, aggravated possession of methamphetamine, a 5th-degree felony. In count, in case number 21 CR 154, defendant is found guilty of counts 1 and 3, and count 2 is dismissed. Court also finds that he made no intelligent voluntary waiver of the rights that he had under as pursuant to Rule 11. Count 2 is dismissed, and as much as there is a stipulated recommended sentence based on the defendant's record, the court feel it is necessary to order a pre-sentence investigation, so we will proceed with sentencing forthwith. All right, Mr. King.
Only those who think complaint records number the forfeiture vehicle on CR 1 days Highland County. Thank you.
And included in the sentencing entry that the county is to release his personal property and personally designates from that vehicle.
Yes, Your Honor.
All right, Mr. Burke, on behalf of the defendant.
You would ask for a 12 hearing in this case, court does recognize my client has a prior felony record, including a case of long Harrison Court. As the PRC, the court policy is typically to close it, very often does. In this case, he is less than a year online on that. He asked me to request that the court consider not closing the PRC, not given that he's almost been deleted.
All right, Mr. Clifford, anything you would like to say? Yeah, well, we're not going to take it forward. I don't have that.
I have to call and get it, Judge.
Okay, I need to know.
Okay.
All right, we don't have a jail time credit on the second case, so Mr. Brown is going to contact them. Let me see if I can reconstruct it here.
We need the 127, Judge.
I have 127, I need 154. You remember when you were arrested on this break-in and entering? It looks to me like it might have been the 23rd of August. Does that sound right? Then you've been in jail since then on this charge only? Are you serving time for that right now? What was your... Pardon me?
He's referring to the indictment.
Okay, okay. Are you serving any misdemeanor sentence right now? They're just pending or what? You being held on bond in those cases? Well, let's see. Well, it looks like there was a $2,500 bond on this case. But it looks like let's see, there were 2 traffic cases and another misdemeanor. So we'll have to see what the jail says about that. All right. Well, with regard to case number 121-127, the aggravated possession of methamphetamine, it's the order of judgment of the court that should be sentenced to the Correctional Reception Center, Portraying, Ohio, for a period of 9 months. In case number 21-154, it's ordered to be sent to the Correctional Reception Center in Ohio for a period of 9 months. Those sentences are ordered to be served consecutively to each other for a total of 18 months. Now, with regard to the PRC time, my policy, Mr. Clifford, is somebody's on PRC and committed a crime, then they need to serve that time. And most of the time they're in on that because of serious penalties they've committed. And you have a very extensive record all over Montgomery County, Butler Township, Kettering, Englewood, Westchester, down in Warren County, Knox County, Tennessee, and burglary in 2014, theft out of Broward County, Florida, trafficking charges in oxy, cocaine, heroin, in Broward County, 2010. For that, being theft in this county in 1997, theft out of Fayette County in 1997, prison term. So the fact of the matter is that when you're out, the public's in danger, and so there's absolutely no reason why any same judge could not impose PRC on you. And so it's ordered the court that you be sentenced for committing these new felonies while under post-release control to a period of 1 year, which is more than what the time is remaining on the post-release control. And that is also ordered to be served consecutively. Now, the court will find that second sentences are being imposed at 127 and 154 because these offenses are separate courses of conduct. and that one single prison term will not adequately reflect the seriousness of the harm caused, and the sentences are not disproportionate to the harm that was caused. Your history that I just gone over, criminal history demonstrates it's necessary for you to have consecutive sentences to protect the public. And the second offense was actually committed a plea. No, you weren't on. Yeah, you hadn't been bound over on that one, 127. So 154 is committed after 127, but not while you charged with it. I'll also make a note that you failed to appear on the first case and were at large until October 17th. And so the sheriff has just told us that you have 20 days of credit on 154, 10/17 to 11/5. And you were being held on the misdemeanor charges before. And in the 127 case, you have 1 day of jail time credit. Now, upon completion of these sentences, it is possible that the adult authority will choose to put you on post-release control, but it's up to them, it's not required. They'll make the decision. If they do, it would be for a period of up to 2 years. If during that period of time they find that you have failed to comply, they can return you to prison. They may serve an additional period in these two cases of up to 9 months, which is half of the prison term that's been imposed. However, and it'd be for one or more about violations. However, if you commit a new felony, then in addition, whatever sentence the judge in that new case would impose upon you, that judge could also sentence you in this case to an additional period of 1 year, whatever time might be left up to 2 years of post-release control, whichever is greater or more. If that occurs, it has to be served consecutively with sentence in the new case. It's also ordered to pay the court costs, which Judge Grant executes order in each case. If you don't, then the clerk will collect that reversion may exclude level of bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of the prison term, you can be ordered to leave service and be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. There's no driving suspension or fine in the 127. There'll be no fine imposed in the case. And it's also ordered that the defendant be permitted to have a designated person retrieve any personal items he has in the vehicle that's been forfeited. That vehicle is ordered to be forfeited to the Hyde County. Who is it? The Hyde County Sheriff?
Yeah, there's a sheriff's office case, but the court will not issue a title.
All right, to the Hyde County Commissioner. All right. Anything further, counsel?
No, Your Honor.
All right, to remand in custody, Mr. Pleasant, thank you. Are you Jacob Wright? Case number 21-0128. State of Ohio versus Jacob Wright. Mr. Wright is appearing by Zoom from the Hyde County Jail. His attorney is Dennis Kirk. He's appearing from his office. Representing the state is Mr. King, appearing from his office. This matter is being conducted by Zoom rather than in person due to COVID-19, and Mr. Kirk, do you and your client both agree to conduct this matter virtually by Zoom rather than by in-person appearance in the courtroom?
Yes, sir.
And you're in agreement with that, Mr. Wright? All right, now, Mr. Wright, since we're not in the courtroom, if you have any questions during the proceeding, just let me know, and I can, if you need to talk with your attorney about those, and just let me know, and I'll put you in what's called a breakout room, where it's good you can talk. No one else will be able to hear you or see you, and it won't be in the report. Okay? All right. Defendant charged with aggravated possession of drugs and third-degree felony. The matter was set for a pre-trial as continued to today. And I've been presented with a plea of guilty form, Mr. Wright, which indicates you're going to draw your not guilty plea and plead guilty to the charge of aggravated possession of drugs in the indictment, third degree felony. I'll hold that up to the camera so you can see it has your case number and that plea form. You recognize that document, Mr. Wright?
Yes, sir.
All right. On page 3, there are signature lines. Not quite halfway down the page, there's a sentence that says, "I enter this plea voluntarily." Right below that appears to be a signature. I think that says Jacob Wright. I'll hold it up to the camera. And is that your signature right below that sentence I'm showing you?
Yes.
All right. When did you sign this agreement, Mr. Wright?
I believe it
All right.
Monday.
Monday? Okay. Did you did Mr. Kirk go over with you and answer any questions, explain to you before you signed it?
Yes.
When you signed it, did you understand it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Now, the agreement states on page 1 that you're going to withdraw your not guilty plea and plead guilty to the charge of aggravated possession of drugs under 29.25.11 on our revised code of third degree felony. Further states that you understand the maximum penalty for that if convicted could be a prison term of 36 months. The minimum that could be imposed, if one is imposed, is 9 months, and then there's certain different levels in between those two ranges. There's a fine available of up to $10,000, maximum, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
There is a presumption that there should be a prison term imposed, but it is not mandatory. Do you understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
Yes, sir.
Are you currently on probation, community control, parole, or post-release control, or a felony from any other jurisdiction?
Yes, sir.
Right now, under the law, if you are convicted of this offense, are not required to sentence you to prison. Instead, I could impose what's called community control, which means that instead of going to prison, you would be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. And if during that period of time probation felt that you were compliant, then at that time they would file a written notice that the court served a copy on you. We would have a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you had failed to comply, then at that time you could have your community control revoked and then be sentenced to 36 months in prison and fined $10,000. You understand that?
Yes.
Now, if at any time you're sentenced to prison, serve a prison term for this offense, upon completion of that prison term, under the law, the Adult Parole Authority has the option, if they could or they could not, they have to, it would be up to them, to put you under what's called post-release control supervision for a period of up to, in this case, 2 years. And so what that means is that you'll be supervised under conditions that they set because the court's not involved in that by a parole officer for a period of up to 2 years. And if during that period of time that you're being supervised, they determine that you had not complied with those conditions, and they could impose a sanction of up to 9 months for any one violation. But there is a cap of half of whatever prison term is served for all violations. But if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in litigation imposed upon you, the judge could also sentence you, in this case, for that violation while under post-release control to a period of 1 year, whatever time is left on that 2 years of post-release control, whichever is greater, which would be served consecutively the sentence in the new case if that occurred. Do you understand that?
Yes.
Right, now the charge alleges in the indictment that on or about January 29, 2021 in this county, you knowingly obtained, possessed, or used a Schedule 2 controlled substance with 3-fluoro-PCP, which is phencyclidine, in an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, violation of Section 29.5.11 of the Higher Vice Code. Excuse me, so that's the charge of aggravated possession of drugs. Third degree felony, as I said, carrying a possible prison term between 9 and 36 months, fine of up to $10,000, mandatory fine of $5,000, any possible license suspension of 6 months to 5 years. Mr. Wright, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it? And have you discussed the nature of the charges, the possible legal issues in the case, the evidence in the case, possible defenses you might try to raise in trial, and possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with his advice and confidence?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Any threats that may get you to plead guilty here today?
No, sir.
Now, on page 2, it indicates it's underlined that you're going to enter a plea of guilty to the indictment, state defense, or your sentence. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
All right, now we have certain constitutional rights you must understand before I can accept your plea. First of all, well, let me back up. Do you hold any license or certificate from any state governmental regulatory agency for a profession or occupation?
No, sir.
Now, you have certain rights that I will explain to you. You have right to counsel. Kirk has been appointed to represent you because you didn't have the funds to hire him or anyone else. So he's representing you. Now, I did appoint him simply to work the case out, but provide any defense could be available to you under the law that you would like to provide. So, if you decide that you do not want to plead guilty, that you want to defend this charge, he will continue to represent you, including in trial, if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that are summoned for jury duty from this county. They live in this county on your trial date. After they were selected, the evidence will be presented, then they would be instructed on the law by the court. They would then decide on a unanimous verdict, 12, after agreeing as to whether or not the state proved your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, then you could waive in writing, which means give up the right to have a jury trial, in which case you would then have what's called a court trial, meaning the judge would be the one instead of the jury who would hear the evidence, apply the law, and decide whether or not the state proved guilt by proving beyond a reasonable doubt. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney in open court. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of the court to tell or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain going to come in voluntarily, you request the court issues a court order that's a subpoena. That forces those people that are named in the subpoena to come to court to testify for you, even though they don't want to be here, which is the same way the state's witnesses will come into court to testify against you. You understand that?
Yes, sir.
And under the Constitution, you have a privilege against self-incrimination in this case. If the right to speech cannot be forced to give evidence in the matter at any time, including trial. No one ever make you testify. The judge can, the prosecutor can. It's up to you. You decide not to testify. The fact that you did not testify will not be used against you in any way, in any person, at any time. No one's even allowed to comment about it, with one exception. That is if there's a jury trial. Then you don't testify. The judge instructs the jury that because that is your right, do not consider it for any purpose. You understand that?
Yes, sir.
Right under the Constitution, you are presumed innocent until proven guilty with the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof is on you to show that you're not guilty simply because you've been accused. In fact, under the law, you don't have to prove anything. You don't even have to present evidence in your own defense in trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state of Ohio. Prove your guilt by proof beyond reasonable doubt every element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Yes, sir.
Originally entered plea not guilty plea denied the allegations in the indictment, denied you committed any crime, and exercised all the rights that I just described for you here this morning. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits the allegation in the indictment, this is their crime, and that you committed that crime. And that plea waives up all the rights that I've just described for you here this morning, except your right to have an attorney. You always have a right to have an attorney no matter what your plea is, with that exception. If you plead guilty, waive or give up your right to a jury or court trial. You would waive or give up the right to confront witnesses against you and cross-examine them through your attorney. You would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. You waive or give up the privilege of self-incrimination because you're saying you're guilty. That's what you defines with. It also waives or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It waives or gives up any right to file an appeal you think you may have had up to this point in the case. However, if I sentence you to the maximum sentence or under certain limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. And finally, it does subject you to being sentenced immediately by the court if I think that's the right thing to do. You understand all of that?
Yes, sir.
If you are you a U.S. citizen?
Yes, sir.
And you're entering into this agreement to plead guilty voluntarily?
Yes, sir.
All right. You have any questions about the charge or possible penalty?
No, sir.
You understand it?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Do you have any questions about the constitutional rights I explained?
No, sir.
You understand it?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
I think I did skip one thing. Are you on community control, probation control, or post-release control for felony?
No, sir.
Okay. All right. Now, is there anything you'd like to speak to Mr. Kirk about before we go any further?
No, sir.
If you have any questions about anything I've gone over with you here today?
No, sir.
All right, is it your decision then, Mr. Wright, to withdraw your guilty plea guilty to the charge pursuant to the terms of the agreement that we just gone over?
Yes, sir.
All right, then as to the charge, which alleges that on or about January 29, 2021 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule 2 controlled substance with 3-chloro PCP benzcycline, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code, charged with aggravated possession of drugs, a 50-degree felony, carrying a possible prison term of between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of up to $5,000, and a possible license suspension of 6 months to 5 years. How do you plead? All right, the court will find that in this day open court defendant is violating all his constitutional rights, made a knowing intentional voluntary waiver of same pursuant to Article 11. Please accept the order filed. Defendant is found guilty of this offense as charged. The court will order a pre-sentence investigation of the same bond. Shall include an assessment for substance use disorder treatment and/or mental health. See the defendants filled out an application for drug court, so the matter is referred to drug court for evaluation. Sentencing will be held on let's see, December 15th at 11 a.m. Bond will be continued. All right, is there anything further, counsel? All right, thank you. All right, are you, Thomas Sean Malone? Case number 21-0158, State of Ohio versus Thomas Sean Malone. Mr. Malone preparing by Zoom from the jail. His attorney is Dennis Kirk, is also attorney from his office by Zoom. And then appearing on behalf of the state from his office is Assistant Prosecutor King. The matter is the defense charged with two felonious assault on a police officer and failure to comply. This matter is set for trial on November 15th. Was set for a pre-trial yesterday. Although I do have first motion to continue the pre-trial from the 3rd until today, which obviously I granted. And then I have a motion here as well from Mr. Kirk requesting a continuance of the trial because of the fact that he had recently been out of the office for illness for over almost 2 weeks and needed additional time to prepare. You can discuss this with your client, Mr. Kirk.
I did, and I also met with him yesterday, and it's possible we can resolve the case next week. He wants to see me again the first of the week after discussing the case further, stating or possibly resolving the case.
Okay. Well, if that doesn't work, we're going to need a trial date. So, Mr. Malone, if the case isn't worked out to your satisfaction, are you in agreement with your attorney asking for more time so that he can better prepare your case to defend you if it's going to go to trial?
Yes, sir.
All right. So, by agreeing to continuance, it waives your speedy trial time. I haven't looked at it, but under the law, you're entitled to be tried within 270 days of your arrest. But if you've been held at any time during this pendency of the charge in jail for this offense only, then you get 3 days for each day received where you were in jail. However, if there are sometimes things that toll or extend the speedy trial time, and so I know there have been some of those things that happened in this case, but again, I haven't calculated it. I know the original date is the end of the speedy trial time, but if you agree to this continuance, we'd probably continue it into December or maybe even early January, and that would extend your speedy trial time until that time. You understand that? And you're in agreement with that? Okay. All right, well, the court will grant the continuance of the trial set for November 15th. As far as another pre-trial, I'll just say to be held if requested. And we'll set a new trial date for December the 13th at 8 a.m. All right. Anything further we need to discuss at this time? All right. And your attorney will be in touch with you, I think, Mr. Long, and we'll see you again when